Thank you. Kei te pai. I call the Honourable Member Materia Ture.
Mr. Speaker, I hope you are similarly relieved by the content of my speech. Mr. Speaker, I have a supplementary order paper on the table that amends various clauses within this bill, including at least one clause in Part 2 and the substantive ones in Part 6. But I would like to take the opportunity to talk with members about the supplementary order paper. What it does two main things. At first, it removes the advisory aspect or the dominance of the advisory aspect from the Māori Committee and makes the recommendations of the Māori Committee concerning patents obligatory on the Commissioner and the decisions that the Commissioner makes. And secondly, it removes the Commissioner from the appointment of members to the Māori Advisory Committee or the Māori Committee and instead replaces that person with the Minister. I just want to briefly outline the issues around why the supplementary order was put together. So we have been committed to making further changes to intellectual property law to give effect to the Y262 claim in the Tribunal report ko Aotearoa Tēnei. Now, we want first to just acknowledge the original claimants of the Y262 claim that was lodged 20 years ago, by more than that possibly, 20 years ago, so by members of Ngāti Kuri, Te Araroa, Ngāti Koata, Ngāti Porou, Ngāti Wai and Ngāti Kahungunu, and that none of those original claimants are alive. All have passed on. We acknowledge the support of those claimants, particularly Sana Murray and Del Wihongi, who were so instrumental in fighting the incursion of genetic engineering into our environment because they believed with all their hearts that we must protect the mauri of Te Ao Māori, not for themselves or for ourselves, but for their tamariki and for our mokopuna to come. So the issues here concerning patents have a very long history, a very long statutory-based history. And unfortunately, in the way that the bill has been prepared and the select committee process for this bill, that history has been largely ignored. And although we cannot fix that failure during this committee process, we can make a small step to trying to remedy at least part of that failure. So we have a SOP on the table which meets some of the submitters, the Māori submitters' concerns about the nature of the Māori Committee, Māori Advisory Committee, which gives it more authority, more decision-making power in the decisions around patents. Now, Mr. Speaker, I will be clear, we do support this bill because it does make some significant improvements to patent law in New Zealand, ruling out patents on humans, on methods of treatment and diagnosis, on plant varieties and on computer programs. And I acknowledge the work of my colleague Gareth Hughes, who was instrumental in campaigning to make sure that those protections were put in place, or those exclusions were put in place. These changes are important and they are way overdue. But the bill does not deal with the issues that were raised in Y262. They do not deal with the issues that were raised by the Tribunal in ko Aotearoa Tēnei, and that means there are serious gaps and flaws in it. So we acknowledge that in supporting this legislation, we acknowledge those gaps, that our bill, our support comes with the knowledge that on mātauranga Māori, there is no real progress here in this legislation. The reason we have made the changes, or that we've put forward this SOP, is to at least give the Māori worldview, mātauranga Māori, Te Ao Māori, the opportunity to have a genuine say at the table. I would just refer members to the Waitangi Tribunal report, who were very careful and very measured. Some said has had some criticism for being far too measured, I have to say, but very careful in stating their view on how Māori should be part of the decision-making process around patents. They said this: the Treaty of Waitangi gave the Crown the right to govern and enact laws, but that right was qualified by the guarantee of tino rangatiratanga for iwi and hapu over their taonga katoa. The courts have characterised this exchange of rights and obligations as a partnership. In this context, tino rangatiratanga means that iwi and hapu are entitled to exercise authority over their mātauranga and to exercise authority over their relationships with taonga, such as cultural works and parts of the environment that are significant to their culture and identity, so that they can fulfil their obligations as kaitiaki. And then the tribunal, so that sets the framework for how these issues need to be considered by the Crown. And the tribunal then went on to say, in relation to changes to patent law in particular, their recommendations, these include the establishment of a Māori advisory committee to advise the commissioners of patents and plant variety rights about whether inventions are derived from Māori traditional knowledge or used taonga species. That is there in a very watered down form in this bill. Establishment of a register of kaitiaki interests in taonga species, granting the Commissioner of Patents the power to refuse patents. Mr Chair. Mr Chair.
The Honourable Member, Materia Ture.
Thank you, Mr Speaker. Granting the Commissioner of Patents the power to refuse patents that unduly interfere with the relationship between kaitiaki and taonga, and introducing a legal requirement for patent applicants to disclose any Māori traditional knowledge used in research, and the source and the country of origin of any genetic or biological material contributing to that invention. Essentially making sure that there is Māori decision making about whether patents should proceed based on mātauranga Māori and the Māori connection, their obligation to be kaitiaki of those natural taonga, that there is an obligation on those seeking patents to provide information about those patents from a Māori point of view. And that they should, and that's good. That means that those organisations, those companies, those researchers, those inventors need to, when they are in this country, a tiriti-based country, take as their first principle, where does the Māori interest lie in the work that they are doing? Whose taonga are they using for their invention? How have they communicated with those people who are kaitiaki? And how do they then work with those kaitiaki to make sure that the mātauranga Māori is respected and restored and protected? And that obligation should be on those who are making the applications. It should be on the researchers and on the inventors, because we must make sure that from the very start, Māori interests are maintained and upheld. And under the current bill simply doesn't deal with any of that at this point. It does nothing about that. We can't fix that at this point in this bill. It does mean that at some point, government is going to have to, well, we would very much like government to take the tribunal report, the findings and these recommendations very seriously and find a way to implement them in this new patents law. We understand that it wasn't widely understood or acknowledged at the time that the bill was drafted and at the time that the Select Committee heard the submissions. But now that we do know, and now that we have the report, and now we have more information and understanding about how the law could better reflect and incorporate mātauranga Māori, te ao Māori into its decision-making processes, we have an obligation as a parliament to make it happen. This is what the treaty relationship requires. So, the Green Party will be supporting this bill. We urge members to support our SOP around the Māori Advisory Committee to at least give some opportunity for Māori to be decision-makers over those issues that are most important to them. It is a small but significant step that could be made today to just take the issue a little bit further, and then for us to find a way to work together in the future, and in the very near future I would hope, to really bring these issues from Aotearoa Tēnei to the fore in further amendments to patent law and intellectual property law. Thank you, Mr. Speaker. Mr. Chair.
Mr. Chair. Mr. Chair.